Let's talk about evidence for the multi-state bar examination and what's tested and how to attack the test. On the MBE, you're going to get about 27 questions in evidence. About a third of them will be hearsay. The way in which you approach all of the subjects in the evidence section is first you have to have a full command of the black letter law. There's no getting around evidence rewards the rote memorization of black letter law. So you need to know it better than you presently do. You need to know it cold. Because if you don't know it cold, you can't apply the law mechanically. We're going to use some illustrations to talk about that as we look through tonight. But what you have to do is raise your knowledge of the black letter law to the point where you then can apply it mechanically, step by step by step, whether it's a best evidence rule problem, whether it's a hearsay problem, whether it's a straight relevance problem. You need to know those definitions cold. If you do, this is an area of the law which will reward that rote memorization and cold analytical application to the point where you can get about 75% of the questions correct. If you do not do that, then you're really guessing and you're likely going to be in the 40 or 50% range. And you know you need to get a combined score, a level of proficiency in this at some point that is going to need to get to about 65% correct. The way the multi-state bar examination scoring works is in Massachusetts you need a combined score of 270 points to pass. Assuming you do equally well on the multi-state as the essay, then what that means is you need 135 points on the multi-state and 135 on the essay. There are 200 multiple choice questions. In essence, 190 questions are graded. They use 10 for sampling, but let's just call it 200 multiple choice questions. In order to get a 135 score on that test, and there usually is a scale of between 10 and 20 points added to your raw score, in essence, you're going to need a minimum multi-state score of 125 out of those 200 questions. That's 62.5% correct. That's a D in the real world, right? That's a D anywhere else. So it doesn't mean that we have to master every single question. But what it does mean is that you should be attacking this subject as well as all the others as you start to do multiple choice questions by process of elimination. You eliminate the incorrect choices in A, B, C, or D. What are incorrect choices for the purposes of evidence? Well, first of all, recognize that what those questions are testing. They are testing the federal rules of evidence. So some of the cases you read when you did the Weinstein book are inapplicable because they weren't federal rule of evidence cases. For instance, there is no federal dead man statute. If the answer on the multi-state bar examination is dead man statute, it's the wrong answer because there is no federal dead man statute. We're now down to 1 out of the 3 potential answers. If there is an incorrect statement of the law as one of our 4 answers, it's the wrong answer. An incorrect statement of the law can never be the correct answer on the multi-state bar exam. Just can't be. So now you're down to 1 out of 2, and you don't need to do much better than that. How do we do better than that? We do better than that by recognizing that there are some rules that require the declarant to be available, others that do not, and only under certain circumstances some evidence is admissible. For instance, if the declarant is not shown to be unavailable, you cannot use the unavailability exceptions, right? So memorize A, what renders a declarant unavailable, B, memorize what those 2 Ds and 3F unavailability exceptions are. If they're then in the answer and the declarant isn't shown to be unavailable, they cannot be the correct answer. You eliminate that choice, you've got the correct answer by process of elimination. What you've got to be careful about in doing these questions is to jump past to excited utterance or some other hearsay exception when the rule itself doesn't apply. They're going to try and trick you. There will be distractors there. But if you apply the law mechanically, then you're likely to win. You know, Joyce screams out and says something. It sounds like an excited utterance. If I have sued Joyce and I do my definition mechanically and I want to offer that statement, Is it an out-of-court statement? Yes. Is it offered to prove the truth of the matter asserted therein? We'll say yes. Is it a party's own statement? A party's own statement offered against her by her adversary? Yes. The analysis is over. It's non-hearsay. It's admissible through anyone who heard it. I don't look for an exception to the rule if the rule doesn't apply. That's why I do it a step at a time. It could have sounded like an excited utterance, might have fit the definition, might have fit the definition of present sense impression, might have been a whole bunch of other things. But if I apply the law coldly, step by step by step, I get the right answer, and I get the right answer without being sent in a misdirection that the person who wrote that question tried to do to me. At this point, they're testing the law. You need to know what the law is cold. You also need to know what that first level of exceptions to the law is, because that's a very fertile area for testing. The multi-state bar examiners have given us an outline of coverage. One of the shorter of those two handouts that you've got is the outline of coverage. And I want to go through that tonight so that you can look at it and think about it. And when you look at that outline of coverage, you should be able to make a sentence for everything that's on that page. And so I want you to start to think about it in much greater detail, what's tested and what they're looking for and what you need to know. Because when we teach evidence in 3 credits, it's a survey. It's a quick, broad brush. We're trying to make sure you may understand the major issues and can apply them reasonably well. When you're taking the bar examination, they test the nuances. They test the exception to the rule of law. They ask you to apply it very, very carefully, and oftentimes you're likely to be down to 2 very difficult choices if you've started to do some of these questions. And a lot of times that's a toss of a coin as to whether you're picking A or C under those circumstances. When you go over these questions when you're done, trying to look for what you got wrong and why to try and improve, don't just look at the ones you got wrong. Look at the ones you got right and make sure you got them right for the right reason, right? As you go through it, solidify your base and add from the ones that you weren't doing well and get that better as you go along. Don't just think that, oh, I got it right, I must know what I'm doing, because if you've started to do these questions, oftentimes you're down to 2. And you probably couldn't really articulate to me well sometimes why you picked one versus the other. Make sure you picked it for the right reason, so next time when you see that question, you will pick it for the right reason as well. But the best way to do this, the best way to make sure that you get into the range where you're comfortable is memorize the black letter law cold. Apply the law mechanically, step by step by step. And then 3, eliminate the choices that are incorrect, either as misapplications of the law, misstatements of the law, misstatements as applied to the facts, factually incorrect, or simply not the proper law. If you do that, you're going to arrive at the right answer more often than not. And this is an area, evidence is an area we can get into the range of about 75%, which is good, because you're going to need a little bit of that buffer for some of the other subjects. Some of the other subjects are not as neatly revolved around the rote application of black letter law. This is one of those that is, if you learn it, and especially if you think about hearsay, which may be a subject that some of you don't feel you have a confidence level in right now, it ultimately is 5% of the entire exam. Right? If it's 9 questions, that's almost 5% of the test itself. If you memorize the law cold, what is hearsay and what isn't, the entirety of the definition of 801 plus the exceptions, you'll then get a significant return on that investment time, because you'll be able to get virtually all of those questions you should be able to nail down. Now, to that end, I've left the sheet up here. We only have a total of 5 quizzes. So I've left this sheet up here if you choose. Put your name on it. 25 of these, which is the full definition of 801 hearsay, and then what are the unavailability exceptions and when can they be used. Handwritten, 25 copies, and you get another 5 on your quiz. Okay? By next Monday. if you want. And if not, I don't care. But that's your call. I can tell you that it'd be time well spent if you haven't mastered it already, because, again, it's nearly 5% of the test. And you've got to know 801 is quite extensive. There is as much testable on the MBE that 801 says isn't hearsay as all the hearsay exceptions combined. And that's why you need to have a full command of that definition. So take out these two handouts, one of which is, I just want you to see their outline of coverage. The other one, more or less, goes along with that outline of coverage. So what it says here is that, obviously, you're using the latest edition of the Federal Rules of Evidence, which is 2011, for the next 10 days, and that's all we've got left. I'd like you to bring an evidence book with you, because some of these rules, when you look at them, are very, very simple. Like the difference between excited utterance and present sense impression are a couple words in each one, and each is only one sentence long. When you have it and you look at it, it's pretty easy to see the distinction, and they may ask you to make that on the bar exam. And there'll be a couple other rules as we go through it that I might want you to look at and point to. So bring a rule book. I don't care which one it is. I've got a thicker one with me, but it doesn't make a difference whether you have a big one or a little one. Just have some type of rule book that we can work through. Also, for the next 10 days, going to be going through this section. Hopefully you've already done it and done all these questions and done the information there. We changed books this year because I think that what you've got is a really a reasonably comprehensive set of bar review materials that you should be working with starting 3 weeks ago at this point. If you do, I think you'll find that you'll be well prepared for it. I really like the questions, even more so. While the questions have been around in various forms, I think they go into great detail the answer to the question and why, and they also are giving you some of the distinctions and the exceptions to the rule, which oftentimes are the highly tested areas. So if you really spend some time with this and pay attention to it, you're going to have a very good command of it. And you want to do that as each section begins. You want to have gone over your notes and the like. As we go over this, if you have a question in an area that's not here, or if I decide to skip it over because I think we've already made that point, ask the question when we're doing that topic, whether it's relevance, hearsay, spousal communications, whatever it is, and make sure you know where it came from so that we can tell your classmates so they can see it, and we can try and explain the distinction a little better if you're cloudy on it or what the answer actually means. If you have a question on a question, the likelihood is someone else has it as well. And so sometimes it can be easily cleared up. Sometimes it's just a damn difficult question and we're all confused on it. But if you've got a question on a topic, as we do that topic, please raise that issue and we can try to address it and help to solidify your base of knowledge and the like. So let's take a look at this NCBE. 1/3 of the evidence questions will be based on category 1, which is presentation of evidence, and another 1/3 comes from hearsay, and so everything else is in the middle. On Saturday, so you understand the schedule, on Saturday we're going to go over those handouts in some detail, the character, habit, impeachment, spousal testimony, and hearsay. Memorize, really get a handle on that, on those handouts. Character, habit, impeachment is by far the hardest area we do. It's by far the hardest area on the bar exam. They know it, and they've increased the number of those questions in recent years. So what we're going to try and do is get the general rules down so that we can apply them carefully. And then once we do, we're going to move on, because character, habit, impeachment is an area we could study forever and still feel some unease with it. It's the nature of putting a whole bunch of different things under one big broad category, and it just doesn't hold together well. If you memorize the general rules, when you see the questions, you should do just fine. Let's talk about introduction of evidence, the requirement of personal knowledge. What does that mean? That means generally when we ask a witness to testify, that witness must have personal knowledge about what they're testifying about. For lay witnesses, we don't care what a lay witness thinks. We care what they saw. We care in some circumstances what they heard. But in order to testify as a general matter, if you are a lay witness, you must have personal knowledge about what you're testifying about. It's that simple. We don't care what they think. The witness must have been able to perceive, understand, remember, and communicate. Right? PURC. P-U-R-C. Perceive, understand, remember, and communicate. Remember, the standard for that is low. Those cases, virtually everyone got to testify except the woman who was robbed in the nursing home who could only raise her knee. She was the only one in that group who was determined to be incompetent. Even the guy was forced to testify in his own incompetency proceeding where they wanted to keep him as a danger to himself. They're different competencies. To testify, it's perception, understanding, recollection, and communication in some way. The standard is low, and the federal rules of evidence allows every witness, presumes every witness to be a competent witness. When can a lay witness, if they have personal knowledge, provide their opinion, what they think? Only in 5 areas that all start with S. Speech, speed, signature, sobriety, sanity, right? That's the only time we care what a lay witness thinks. If they have personal knowledge about those observations, they can then tell us what they think about speech, speed, signature, sobriety, or sanity. Leading questions. As a general matter, when you put a witness on the stand, you've called that witness, you cannot interrogate that witness with anything other than non-leading questions. Who, what, where, when, how, describe, or why. What's a leading question? A leading question is one which suggests the desired answer, is the legal definition. As a general matter, if a question can be answered yes or no, it should be considered leading. But you can phrase them either way. But at least our gut would say, if it's yes or no, it may very well be leading. That's on a direct exam of a witness you call. When can I lead? What's the exception to the rule? The exception to the rule, when on a direct exam, young witness, old witness, hostile, or it's a preliminary question. Young, old, hostile, or preliminary. That's what they're going to test, right? The exception to the rule of law. Even still, of the young or old witness, you should not be leading on a matter of central importance.
You said young, hostile, old?
Young, hostile, old, or preliminary. Cross-examination. What's the scope of cross-examination? B, C, D. Bias, credibility, and the subject matter of the direct exam. B, C, D. Bias, credibility, and the subject matter of the direct exam. What type of questions can I ask on cross? Again, look at the call of the question. They're not asking you what you should do. If the call is what type, may the witness be led? May the witness be asked of questions, not non-leading questions? On cross, as a matter of law, as long as it's within B, C, or D, I can ask any type of question. As a practical matter, as a tactical matter, we only ask leading questions on cross. But that doesn't mean what I'm permitted to ask. I can ask non-leading questions. You just don't do it from a practical standpoint because it's just unwise for the cross-examiner to do so. But if the call of the question asks you what may the witness be interrogated with non-leading questions on cross, the answer is yes. Relevant scope across B, C, D. Bias, the fact that you've been paid to testify, the fact that you are related to one of the parties in the case, the fact that you have a financial stake in the outcome of the case, permitted as of right. Now, as of right, when we talk about that, when we talk about the judge's discretion, the trial court's discretion being removed, those are highly tested areas as well, and here's why. Think of how quickly things happen at trial. Seconds, really, for the trial judge to make a ruling. And so we give, the appeals court gives, the law gives, a great deal of latitude in the court, at the trial court level, in deciding most things. And that's the general matter. If the question says, may the trial court do this or that, 90% of the time, they may do just about whatever they choose. Must the trial court? When are their hands tied? When don't they have discretion? That's something you really should start to make a list of as we go through this. Because when their hands are tied, that's when the general rule is inapplicable, and that means that's likely to be a highly tested area. As of right, I can inquire into bias. As of right. C, credibility. As of right, I can inquire about a witness's prior criminal conviction that is less than 10 years old if it's for a crim and falsi. As of right. So that's two areas right there where the court cannot prohibit me from inquiring about that. The point is, you want to look carefully at when the trial court's discretion is removed, because that's a highly tested area. C, credibility. Every witness, every case, when they take the stand, they place their character for truthfulness in issue. You have a handout. We're going to go over this on Saturday about methods of impeachment with prior convictions. It's a straightforward rule. Less than 10, more than 10, less than 10, crim and falsi or felony. But there's no way of getting around memorizing what the rule is. And you're going to see questions on this. If you memorize what the rule is, we'll talk about it on Saturday, it's actually a pretty straightforward application of how old is the conviction and what is it for. And then we can decide whether it comes in or not. But if you don't have the rule down, it's going to be hard to apply it. You're not likely to get it correct. So look at that handout carefully. We do impeach a witness with their prior criminal offenses, and there are, depending on how old it is and depending on what it's for, there are different rules. Take a look at that, and we'll talk about that on Saturday. Biased credibility, by the way, credibility doesn't just mean your convictions. It means your prior bad acts that are probative of truthfulness I can inquire about. Not even convictions, not even charges. Amy, isn't it true you lied on your application to law school? Prior bad act probative of truthfulness. I can inquire. I can inquire about her reputation in the community for honesty. I can call witnesses to say Amy's known in the community as a liar. I can use her prior inconsistent statements to impeach her. Once the witness takes the stand, every case, civil or criminal, their character for truthfulness is now fair game. And we're going to look at a variety of ways that character can be attacked. And the last part of that is D, the subject matter of the direct exam. Not just what was inquired on direct, but the subject matter on the direct exam. Redirect, right? Now we're back on that side of the equation. Non-leading questions again. You are only permitted to use non-leading questions because, again, this is an examination of a witness you called. What am I entitled to inquire about on redirect? It's not everything that was discussed on cross, not as of right. Only significant new matter raised for the first time on cross. As of right on redirect, I can inquire about significant new matter raised for the first time on cross-examination. As of right. Again, meaning if the trial court limits my ability to inquire about significant new matter raised for the first time on cross, it is reversible error. What can be used to refresh a witness's recollection? Page 3. Anything. Right? Younger says, assent, a song, you name it. Refreshing recollection. Anything can be used to refresh recollection. Because once I do have that memory refreshed, I'm now testifying about what I remember. Must be a song that triggers memories for you. Sense. I write SPV on the board, it'll trigger those horrible memories from first days of law school for some of you, right? It's not what I use to refresh recollection that's important. You now have a recollection. And you get to testify from your memory as to what those events were. That's fine. Anything can be used to refresh. Here's the rule, though. If something is used to refresh, and that memory is refreshed while on the stand, the opponent has the right to examine it. The right means the trial court can't say no. Okay, again, another one of these times where the discretion is limited. If what was used to refresh the police officer's notes prior to taking the stand, for instance, the court has discretion whether you get it or not. That's the rule. That's what you got to remember. Okay? Questions on that? Now let's talk about it's frequently confused cousin. Past recollection recorded, right? Past recollection recorded, I know they're frequently confused, but they're very, very different, first of all. When we're talking about memory refreshed, it could be Joyce's bottle that somehow remembers, oh, now I remember what we were drinking that night. It wasn't water, right? But it's this triggered my recollection, but I'm testifying about what I know. In past recollection recorded, is it an out-of-court statement? Yes. Is it offered to prove the truth of the matter asserted therein? Yes. It's not a party statement, agent statement, or co-conspirator statement, and it's not a prior statement of a witness who's testifying at trial because the witness, in essence, is saying their memory is sufficiently infirm that, for all intents and purposes, they're not testifying at trial. And it's not inconsistent, even if they were, it's not inconsistent yet because they haven't said anything, and it's not consistent, it's not one of ID. It's hearsay. Past recollection recorded is hearsay, that's why it needs a hearsay exception. Okay? Present memory refreshed is simply my own memory about what I know. In order to get past recollection recorded in, the witness must be available and testifying on the stand. It is the only hearsay exception that requires the declarant to be available. The only one. What does that mean for the MBE for you? What that means is that if we have an answer within those 4 answers that says past recollection recorded, and the declarant isn't available and on the stand, the answer is no, it's not. Can't be past recollection recorded without the witness laying the foundation for it. Therefore, the witness has to be available. If the witness is available and testifying, the foundation is, I had a memory. When I did, I reduced it to a writing or recording. It was truthful when I did it. Looking at it now doesn't help refresh my recollection. Sorry, I see what it says, but it really doesn't help. At that point, you have laid the foundation for past recollection recorded. It can come in. But there's a trick here. It has to be read into evidence if it's a written statement. It has to be played into evidence if it's a recording. Stupid-ass rule, but we don't fight what the law is. The law, that's what the law requires. On past recollection recorded, the information can be admitted into evidence, but it has to be played into, if the foundation is laid, but it has to be played into evidence or read into evidence. Past recollection recorded, the opponent has the right to offer the thing into evidence, not the proponent. It's the only hearsay exception which requires availability, and that's because the foundation has to be laid using those 4 steps I talked to you about. It's different from memory refreshed because it is proving an out-of-court statement. Memory refreshed, I'm offering you my observations, in some cases what I heard, but I'm offering it from my personal knowledge, not some document that was used to help me with my song I heard or whatever, anything else along those lines. Objections and offers of proof. The way we protect our evidentiary record is by making an objection if we want to keep evidence out. 2 different kinds. General objection doesn't state the reason. Objection. Specific objection. Objection hearsay. The rule is this: on a general objection, if there's any reason to sustain the trial court, the appeals court should do so. Any reason. On a specific objection, the appeals court must look at the grounds for your objection and rule on those grounds. So obviously the best way to protect your record on an objection where evidence comes in is to make the specific objection, because then the court has to look at your stated reasons. Otherwise, if you make a general objection, if there's any reason to sustain the trial court, the appeals court should do so. Offers of proof. On excluded evidence, if you want to preserve that issue for appeal, you must make what's known as an offer of proof unless the answer is obvious. What caused Professor Coyne to fall as he was going down the stairs? Objection, sustained. If you don't make an offer of proof at this point, we have no idea what the witness would have testified to. Neither does the appeals court when they look at that transcript and you say this was error. How do we know it's error if you don't tell us what it was and we can determine whether the person was competent to give that information? Your Honor, may we be heard at sidebar? Yes. Your Honor, if the witness was allowed to testify, he would say he observed Professor Coyne step on the rotted step that was at the top of those stairs, and as soon as he did, the step gave way and he tumbled over the stairs. That answer should have been permitted. It wasn't opinion, it's what he observed, and therefore it was admissible. You make an offer of proof on excluded evidence unless the answer is obvious. That's the way you preserve that for appeal. Lay opinions and expert witnesses. We already talked about lay witnesses who can give their opinion regarding speech, speed of a vehicle, signature, looks like someone's handwriting, speech, speed, signature, sobriety, Joyce appeared drunk, sanity, speech, speed, signature, sobriety, and sanity, all within a lay witness's understanding in order to provide that opinion. If we're talking about an expert testifying, it's background, education, experience, and training, right? The foundation for an expert to testify, beat. Background, education, experience, and training, such that the expert's testimony will aid the understanding of the event. Under those circumstances, the expert can opine if it will aid the jury's understanding of the event, but the expert can never opine about the ultimate legal conclusion, i.e. that the doctor committed malpractice, that the defendant was negligent. You can tell us the ultimate factual conclusion. In my expert opinion and analysis, the accident was caused by Joe when he sped around the corner, was unable to control the vehicle, entered into the plaintiff's lane of traffic, and collided with the vehicle at that point. The jury will make the determination correctly in that case that he was negligent in failing to control his vehicle. While we're at it, it comes later in the handout, but if the expert is going to talk about scientific or technical information, then post-Daubert, it's no longer enough to establish that the information is sufficiently reliable, but post-Daubert, it's going to have to pass the test of Daubert, and that's 4 P's and a T. It must be based on principles of science. It must have been published. It must have been peer-reviewed. The potential for error must have been examined, and it should have been subject to some form of testing. 4 P's and a T post-Daubert for scientific or technical information, no longer enough to show that it is sufficiently reliable and trustworthy. If it's going to be portrayed as science, it's got to walk and talk and act like science and be subject to some of the tests of science. Competency of the witness, as long as they can perk, they come in. Federal rules of evidence presume every witness is competent. Judicial notice. Judicial notice allows the court to establish facts that are either beyond dispute or capable of ready determination. At common law was sun rises in the east, sets in the west, 2 + 2 = 4, things that no one could dispute. The modern rule is that not just those facts, but any fact capable of being readily ascertained and verified. Could the court judicially notice that mass school law is at 500 Federal Street? Yep. Could the court even judicially notice that Route 93 is a way in which the public has a right of access, or a public highway? Yes. Even if it was one of the elements in a DUI case that the defendant was operating on a public way? Yes. Yes. If it is a fact capable of being readily ascertained and verified. Even on its own initiative, the court can do it, or at the request of either party. Huh?
Doesn't it have to be at the request of either party?
Nope. At the request of either party or on the court's initiative, they can take judicial notice. In a civil case, facts judicially noticed are conclusive. In a criminal case, the jury is free to disregard the facts judicially noticed. Jim.
Does the internet open that up a lot more now?
Does the what?
Internet?
Oh, because it's easier to verify facts, it opens it up, and it also, yes. Yeah, the answer is yes. The straight answer is yes, because it's more readily, things are much more readily ascertained and verified, and more quickly. The problem also is we go on the internet and find a lot of BS facts, as you well know, too. So it does, but this is the point here. It's facts. These can't be opinions. These have to be facts that can be readily ascertained and verified. So, facts. You got to make sure we understand that that's what we're talking about. That the White House is at 1600 Pennsylvania Avenue. Yes. That whatever president you don't like was a jerk. Not a fact. Right? Go ahead.
If one of the sides misses the element, so like say prosecution misses.
Yeah, I know. Doesn't that bother you?
Can you take judicial notice?
On its own, yeah. Let me make this point, because this is bothersome, right? And this is a general bothersome to me when either you try cases or when we fake tried cases. Okay, so you're winning, right? The other side has forgotten something, or the other side hasn't done a really good job on this cross-examination. All of a sudden, the judge decides, I've got a few questions of my own. And you sit there saying, what the hell? What the hell? I'm not playing you and him. I'm just playing him. Can the judge interrogate a witness under the rules? Yes, you may not like it, but they can. I'm defending a DUI. Government has failed to prove that 93 is a public way. They've offered no evidence on it whatsoever. They're done with their witnesses. All right. Judge before the government closes says, you know what? I'm going to judicially notice that Route 93 is a public way. An essential element for conviction here on a DUI. May the judge, and listen, this would stick with you, right? Because you'd say, no, he can't do that. She can't do that. Yes, she can. Yes, he can. Even on its own initiative. And it really, that's the type of situation that would bother you, because in another second I win. Direct it out. Can the court on its own? Yes. Now here's the only rub with that. In a criminal case, even though the court has judicially noticed it, the jury could reject it. Okay? They can. And that's the problem. But that's the problem with it, is you're right. You say, that doesn't seem fair. It is, because the rules permit the judge. Again, this is within the judge's discretion to do a lot of things. And at the end of the day, remember what we're saying here. Judicial notice means that we don't want the court's time wasted with things that are absolutely factually true. It just doesn't seem, when it's an element of the crime, that should be fair. But in theory, it is. In practice, if you're sitting there, it doesn't seem very fair. And I'm with you on that. Go ahead.
Pinpoint them said that the internet opens it up more for judicial notice.
Yeah, because
I remember on the assessment test, it says, blah, 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 judge goes into his chambers and looks up on the internet.
Yep.
How do I know what he looked at was good?
Well, you don't. That's the problem, right?
You can't say, that's not true, Judge.
Well, but either it is or isn't a fact. See, here's the point. At the end of the day, it's got to be a fact. There will be some things I find on the internet, even from Joyce at yahoo.com, that'll be accurate, and they will be factually true. But there'll be other things I find on Wikipedia that just simply are not true. And so the question is, at the end of the day, whether it's a fact. It's not whether the manner in which you acquired knowledge of the fact.
I'm saying, but if the judge comes back and says, I saw this on the internet, what's your source, Your Honor?
No. If it is a fact capable of being judicially noticed, that's fine. But listen, there is a distinction in some of the questions, and I'm not sure you've got the right. I'm not sure which your question is. But there's another part here. There's another question which says, hey, the judge says, listen, I lived at the intersection of Route 125 and Hillside Road. That's a dangerous intersection. That's not capable of being judicially ascertained and verified, because it is not. So it's therefore not eligible for judicial notice. Some facts are facts. Remember the case in the book was Tresniak. It was the marriage. And the judge said, listen, I know law school is very time-consuming and difficult. I'm going to judicially notice it. Not things you might know from your own experience, but facts capable of being readily ascertained and verified. The fact that you found it on the internet, and if it is a fact, though, if it is a fact capable of being readily ascertained and verified, it's still judicially noticeable. That's the bottom line. The source might make you suspect the fact, but it doesn't mean it's still nonetheless not a fact. And I think for the same reason, okay, so you find something in Grey's Anatomy, that likelihood is it's true, but if it's not a fact, it's not capable of being readily asked, it's not judicially noticeable. Okay? Roles of judge and jury. When I had you guys for Civ Pro, I told you judges determine questions of fact, juries determine questions of law. As far as that goes, that's accurate, but it doesn't go far enough. Because when we're admitting evidence, that is a mixed question of law, the admissibility of evidence, and fact in order to determine whether something's admissible. For instance, in order to admit a dying declaration, the judge determines the admissibility of evidence. Juries determine the weight. In order to determine the admissibility of a statement as a dying declaration, factually, the judge has to find that the original declarant is unavailable, right? Dead, exercising a privilege beyond the subpoena power, or incompetent. Factually, the judge has to make a determination that the witness believed that death was imminent. And the judge also has to factually look at the statement to determine that the statement described what the declarant believed to be the cause of their imminent death. All of that is required. The judge can make those factual determinations in ruling on the admissibility of evidence. In doing so, the court is not bound by the rules of evidence. What that means is the court can use inadmissible evidence to make those preliminary determinations in admitting evidence. One of the questions you're going to see is, and we'll use the dying declaration, the EMT provides the court with an affidavit that shortly before he made the statement, he was given his last rites by the priest. And then I told him, sorry, buddy, I can't do anything more for you. You're dying. Do you have any last words? Did it all in an affidavit. The affidavit is submitted to the court. May the court consider the affidavit in ruling on the admissibility of the statement as a dying declaration? Yes. Even though it's hearsay, the court can use hearsay in making its factual determinations about the admissibility of evidence. Okay? So the court has to make some of those factual determinations, and they will do so. Limited admissibility. Some things come in for one purpose and not others. Prior convictions, generally only for impeachment purposes. Prior inconsistent statements, only for impeachment purposes. Limited admissibility. Just because a piece of evidence comes in doesn't mean it comes in for everything. Burden of proof, burden of producing evidence, the burden of proof and persuasion is generally going to be with the plaintiff, whether it's clear and convincing evidence that needs to be established or preponderance of the evidence. Even in a criminal case, the proof rests with the government to show guilt beyond all reasonable doubt. Some cases, like discrimination, once the plaintiff has come forward with a prima facie case, at that point the defendant has to offer some contrary evidence, any contrary evidence, and if they do not, they lose. But if they do, the burden, again, rests with the plaintiff to show both liability and damages. There are some things that help aid our burden of proof, like presumptions. The mailbox rule says every item that's mailed in the ordinary course of business is going to be presumed to be received within 3 days. For our driving under the influence cases in Massachusetts, there's a presumption that if you blew a .08 or better on that breathalyzer, you are presumed to have been intoxicated and sufficiently impaired to violate the statute. Presumptions. Most presumptions are what we call bursting bubbles, so that when there's been contrary evidence, the presumption's just gone. But presumptions help ease our obligations to satisfy our proof. They don't really shift it, they just make it easier for us to establish our case by the proper evidence. We already talked about the relevant scope of cross. Let's talk about impeachment and rehabilitation, and it says here you're likely to see 4 questions in this area as well. And you have a handout on this, And so I really want you to go over that handout carefully before we look at it again in some detail on Saturday. But there's a bunch of different ways that we attempt to impeach a witness. And the most common of which is once a witness has testified, if there are prior inconsistent statements of that witness out there, the prior inconsistent statements are coming in. And that's logical, and it should be, right? The witness has got up there, promised to tell the truth, but at some point earlier in time, they told a story that's inconsistent with what they just said. So think about that. Shouldn't the prior inconsistent statement come in? Do your definition. Yeah, is it an out-of-court statement? Yes. Offered to prove the truth of the matter asserted therein? Yes. Party's own statement offered against the party? No. Agent? No. Co-conspirator? No. Is it a prior statement of a witness who testifies at this trial? Yes. Is it inconsistent with that testimony? Yes. It comes in. Your only analysis then is, what is it coming in for? Is it coming in for impeachment purposes, to cast doubt on the testimony, or impeachment and substantive evidence? And this rule is pretty straightforward and easy. Prior inconsistent statement of a witness who testifies at trial, only for impeachment, if it wasn't under oath. The one that's under oath should get more weight, and the rule says that. Prior inconsistent statement of a witness who testifies at trial and it's under oath, the earlier statement, comes in for substantive and impeachment purposes. So a prior inconsistent statement is coming in. What they're going to ask you to do on the exam is draw a distinction. For what purposes? Impeachment only, or impeachment and substantive evidence. And by the way, substantive evidence just means proof of the matter asserted, right? To offer the truth of the matter asserted therein. Now, there's a rule, and it's a difficult rule. The rule says you can impeach hearsay declarants in the same manner as if they took the stand. What that means is this. Joyce screams out, look at Professor Martin's driving down that street so fast, he's going to kill someone. Seconds later, Dan is run over by a vehicle. And Dan sues Professor Martin because he heard Professor Martin is the one who did this. The next day, Aaron says to Joyce, hey, so you saw what Professor Martin did to Dan, huh? And she says, no, I just yelled that out because he gave me a lousy mark in torts. I wanted to get even. So let's try the first one. Dan calls. Well, who does Dan call? He wants to offer the statement made just moments ago that Joyce screamed out, look at Professor Martin, he's going down that street so fast he's going to kill someone. Anyone who heard it, right? Anyone who heard it. Why is the rule that anyone who heard it is an appropriate witness? Because they have personal knowledge, right? That rule is simple, but you've got to get that down. If we're going to admit a hearsay exception, it comes in through anyone who heard it. Anyone who heard it. Do I need the speaker? No. Could I use the speaker? Sure. Unless it's one of the 2 Ds and 3 Fs, and then they can't be around. Anyone who heard it is competent to offer it. So, Dan calls Jim. What did you hear Joyce scream out at 6:50 during comp class? Objection, hearsay, out of court statement. Yes, offered to prove the truth of the matter asserted therein. What is the truth of the matter asserted therein? In this case,
He was hit by the car.
Martin was speeding, right? That's the truth of the matter. Is that why you're offering it? Yes. Out of court statement offered to prove the truth of the matter asserted therein. Not a party's own statement, not an agent statement, not a co-conspirator statement, not a prior statement of a witness, because it's coming in through anyone who heard it. It's hearsay, but it's, what do you like for an exception?
I was excited.
Excited utterance?
Yeah, I was excited.
You like excited utterance better than you're always excited. You like excited utterance better than present sense impression?
It was my present sense impression.
Which one is it?
It's present sense.
What if they asked you to draw that distinction? Do you know the distinction?
Yes.
Yeah, I agree.
Is she available?
Is she? She's available. Well, does it matter? Let me ask that. Oh, stop. Does it matter? She's unavailable. How would that help you in this case? 2 Ds and 3 Fs.
Available.
Not a dying declaration, not a declaration against interest, not form of testimony, not family history, not forfeiture by flight of a witness.
It's a spontaneous.
It says it's what goes into our spontaneous group. What do you got for me, Aaron?
I was going to answer your first question.
Which is?
The present time question is
Louder.
your statement while you're observing the event that's transpiring.
Is that what this is? Statement describing or explaining an event while perceiving the event or immediately thereafter. Is that what this is? Or is it an excited utterance? What's the difference? A statement describing or explaining a startling event made while under the stress or excitement caused by the event or condition. What are you going to go with, A or B? Ed says A, right? Present sense impression. Let's take a vote. Present sense impression. I think that's probably the neater fit. Listen, by the way, if excited utterance was the only one there and present sense impression wasn't, I'd be taking excited utterance, right? Because it's close enough. Sometimes they can be both. I hope they don't make you draw that distinction, but if they do, you need to understand that the distinction is kind of narrow. On present sense impression, any event fits. Excited utterance, startling event. On present sense impression, virtually contemporaneous with the event. Excited utterance, under the stress or excitement caused by the event or condition. Could that be even next day?
Depends on how startling it is.
Right? I was even thinking, could you have one a month?
No.
I don't know. Another day we could have another. I can't do it now. Another day. Go ahead.
It's just a bit confusing for me in the sense that she didn't witness the actual collision. They're just testifying as to what Joyce said.
Right.
So is it a spontaneous utterance or excited utterance at that extent? Because she didn't.
Well, the event she's testifying to isn't the collision with Dan, it's that she observed Professor Martin speeding down the road immediately before the crash.
So to
That's the event her present sense impression refers to. And that's the argument.
But-
Yeah, no, that's fine. That's fine. Go ahead, Jim. Hold on.
Book said an hour's too late for an excited utterance.
I don't agree. I don't agree, and I'll tell you why. Rape victim,
All right.
hours later, next day. I don't agree with them that an hour is too much, depending on the level of trauma imposed. Some people will go into virtually a catatonic state for a period of time. I'm not going to give you forever on that, but I might give you the whole night, and I think we'd find cases that would. And what about this? We knock her unconscious.
Damn.
She doesn't get up, doesn't come awake till the next day. When she does, God, why did Jim run that light and kill me and hurt me like this? Could you have an excited utterance some period of time after the event? All I'm telling you is I can make that argument as a lawyer. Be careful making it on the bar exam, but you have to look at it factually as to how it's developed. Obviously, the longer in time away from the event, the less you should be under the stress or excitement caused by the event or condition. But I think there are some events that would be sufficiently startling that you would be expected to be under the stress or excitement for some time, and I think logically you could make that argument. I don't disagree that to me an hour can be tight, because you're in a rural hospital, not even rural hospital, up in North Conway, they're going to take you to Portland. That's at least some time away. Could you still be getting treatment from the actual event, but still be under the stress or excitement caused by the event or condition? Until you're better, until you know you're safe, I think the answer is yeah. So go ahead.
In juvenile law with Dean Calvis, we learned that staggered confessions are allowed from children because the nature of when they're child molested, they're allowed to stagger. So wouldn't that fit into also?
I don't know. Your confessions would be from the perpetrator you're now talking about.
No, the children.
Oh, so they're not confessions. They're
confessions.
recounting the event.
Children will say, I was touched, and then,
Right.
the one burst out a
Yeah.
month later, and they allow that in juvenile cases.
A month later,
They allow them to stagger them because they said it's the nature of sexual.
I hear you. The longer the time removed from the actual event, the harder it's going to be to establish you're still under the stress or excitement caused by the event or condition, at least from the standpoint of an evidentiary basis. I have no doubt that victims of violent crimes along the lines you're talking about potentially could be under the stress or excitement for a decade after the event. I don't think that is not going to pass muster with this rule, which requires, this is one of our what we call spontaneous exceptions, which virtually does require immediacy to the event. And so you got to be careful how far you go. As Jim says, the book says an hour. You're now
I'm pushing.
30. Yeah, pushing it. You're 30 days out. Listen, we got it. No, stop. We got to go back. No, we got to go back. I didn't finish the rest of this, so we're on impeaching the hearsay declarant. We're not even on excited utterance right now, right? So listen, her present sense impression, we now decide, comes in, right? And it comes in through anyone who heard it. That's what we said. What about her other statement? Your other statement to Erin that, I know what I said, but I lied. I was only mad at Professor Martin for giving me a lousy grade in torts. She didn't physically testify. She testified through someone who heard it. But this is the rule about impeaching the hearsay declarant in the same manner as if they testified. If she testified, could that statement come in as a prior inconsistent statement of a witness who testifies at trial? The answer is yes. Since, in essence, she testified through someone who heard her hearsay, her prior inconsistent statement can come in as well. And as Jim points out, since it wasn't under oath, only for impeachment purposes. You can impeach the hearsay declarant in the same manner as if they testified. Her prior criminal convictions for perjury, less than 10 years old, absolutely can come in. Calling people who know of her reputation in the community as a liar can come in. Everything I could do if she testified, I can now do because I can impeach the hearsay declarant in the same manner as if they testified. That's the rule. It's a tough rule, but you better be prepared to apply it because they're going to test it. Okay? Let's see. Bias and interest. As of right, I can inquire into bias and an interest in the case. As of right. Conviction of a crime. Look carefully at that handout. We'll talk about that on Saturday. Under what circumstances can I use your prior criminal convictions for the purposes of impeachment? Specific instances of conduct that are probative of truthfulness, I can inquire about and impeach you with. Unconvicted acts. Isn't it true you lied on your application to law school? Isn't it true you lied during your own divorce case? Specific acts probative of truthfulness. But the rule is this. I can inquire about them, but the inquiry ends with the inquiry. Even if I know I can prove you to be a liar. Isn't it true, Amy, you lied on your application to law school? No, I didn't. I know it's a lie. I've got the proof. She can't contradict it. The inquiry ends with my question. Because I cannot introduce extrinsic evidence, meaning other than from Amy's own mouth, on what's known as a collateral matter. Okay? And it's collateral to the issue at hand because it wasn't relevant to the initial matter of PVD, plaintiff versus defendant. What happens is in your mind you say, but it's relevant now. We can blow out the only real witness to the case. We can blow their credibility out. Doesn't make it relevant to the initial matter. You're still trying to impeach with extrinsic evidence on a collateral matter relative to a specific instance of misconduct. You cannot do that. Character for truthfulness, as I told you, every witness, every case places their character for truthfulness in issue. Ability to observe, remember, or relate accurately. If you wear glasses and need them, if you've got a bad memory, all of that's fair game on cross in an effort to impeach you. Once you have been impeached, we then have the opportunity to rehabilitate the witness, to offer their prior consistent statements, to rebut an express or implied charge of recent fabrication, contrivance, influence, or motive, to offer other witnesses who know their reputation for truthfulness in the community to come in on their behalf and say, no, Joyce is known as a truthful, trustworthy person. But you have to be impeached before you can start to bolster or rehabilitate a witness. You can't do it in an effort to try and give them greater credibility until they've been attacked. Relevancy and reasons for excluding relevant evidence. About a half a dozen questions here. Material. Is it a fact of consequence to the lawsuit? Something's relevant if it helps to prove something that's material. Relevance is, does it have any tendency to make a fact of consequence more or less likely? Does it have, or does it tend to make a fact of consequence more or less likely? Now, even in a criminal case, we use the same standard for the admission of evidence. It's not beyond a reasonable doubt. It's not clear and convincing evidence. It's not even a preponderance of the evidence. Does it tend to help prove or disprove a fact of consequence? That's a really low standard for what makes something relevant. And it doesn't change whether it's criminal or civil. What you tend to do is you guys sometimes look at the piece of evidence and say, well, that's not going to get to beyond a reasonable doubt. One piece of evidence doesn't have to. It has to be the totality of the evidence at the end that gets us there. Same thing with preponderance. It doesn't even have to meet a preponderance standard. Does it tend to make a fact of consequence more or less likely? Whoa, that's real low, right? That's a real low standard, and that's the way you have to think about it. So relevance is a very low standard to meet. The burden of proof is going to stay where it was, but do not change it simply because it's a criminal case. And with respect to 403, where we talk about excluding relevant evidence, 403 talks about a misuse, an improper use of the evidence. And that's the way you have to think about it. Not that the evidence is highly damning. This is a rule that is frequently confused and misunderstood. Immediately before class, before I enter the room, you hear what is unmistakably a gunshot. I come in the room, I have something sticking out of my pocket like this and a little plume of smoke coming out of the pocket. You say, Joyce says, what was that noise out there? I say, nothing. She, despite me telling her nothing, she opens the door. She sees Professor Rudnick's dead body on the floor with blood oozing from her brain. Joyce comes back, looks at me, sticks her hand in my pocket, and pulls out the proverbial smoking gun. Ballistics later matches that gun to the bullet found in her brain and test it and find my fingerprints on that gun. On a scale of 0 to 10, how relevant is it that the handgun used to kill Professor Rudnick was found still smoking in my pocket moments after you found her dead body outside? Give me a 0 to 10.
10.
10, right? There really isn't much number less than that. On a scale of 0 to 10, how prejudicial is it? No, you know better than that. Here's the prejudice you're looking for. An improper use of the evidence. A misuse of the evidence. How likely is it that they would use that handgun for any other purpose other than what the government is offering it for? That's the prejudice you need to find. 0 to 10. Give me a number.
I don't understand the question.
That's too bad then. 0 to 10. What do you got? 10?
The government would misuse it? In the sense
No, not that the government, well, that the jury would misuse it in their analysis.
Oh, 0.
Then much better. The answer is 0. Listen, and here's the thing. Even if you misunderstand this and say it's a 10, you only exclude evidence under 403 if it is substantially more prejudicial than 10. The fact is, this evidence isn't likely to be misused at all. The jury's going to use it for, it's the smoking gun, it ties ballistically to the murder. There's nothing else it can be really received for. Here's an example of the prejudice that you'd be worried about from the misuse of the evidence. Guys on trial for rape. Within the previous 10 years, we have 10 convictions for rape, all done in a variety of ways. So it's not motive, opportunity, intent. He wants to testify, though. He wants to say, not this time. Not this time. So he wants to take the stand. If he takes the stand, I'm the government. I have the right to use those convictions. Not the right. I can use those convictions. Since they're all less than 10 and felony convictions, I can use them if he testifies to impeach his credibility. To say he's not trustworthy, he's a liar. You're sitting on that jury. When you hear there are 10 previous convictions for rape, and he's charged with rape here, Are you going to confine your use of those convictions for credibility? Or are you going to say, this bastard's never getting out again?
Never getting out again.
You're going to use those to find guilt. That's an improper use of it. You're not going to limit it to credibility. You're going to say he's a rapist and he doesn't deserve to be out on the streets. Send him away forever. When they're only offered for credibility. 10 prior convictions for rape. On a scale of 0 to 10, credibility? 3? 4? I don't know where your number is. 5?
You're asking me if he's credible and he raped 10 people? And you brought that in the evidence?
I'm saying when you hear that he's got felony convictions for rape, do you think that casts doubt on his credibility?
Yes, of course.
Does it? Credibility?
He's
Okay, but what's the number then? Tell me the number.
0. You say he gets on the stand and he said I didn't do
He says, I didn't do it. But these convictions aren't coming in to say he's a rapist. They're coming in to say he's a liar.
Oh, well, then no.
Okay, listen. I don't care what your number is. I don't think it's past 5. What's the likelihood of the prejudice from those convictions, the jury using them for much more than credibility? 10? Substantially more prejudicial than probative. A misuse of the evidence. That's what 403 is designed to protect against. That was the point of that discussion. That's what I want you to look at. You understand, for relevance, confusion, wasted time. Character, you have a separate handout on character we were going to talk about on Saturday. Character is one of these areas that is frequently confused. But here's the deal on character. It almost always is going to be a criminal case issue because there's very few civil cases where character is relevant at all. Slander is one of them, but that's about it. There aren't a lot. Even in the civil criminal cases where character is an issue, the accused has to raise it first by offering relevant character traits. Please look at that handout because I think we can really clear up some confusion on Saturday in this. But the biggest one starts as you start doing your questions is it isn't even an issue in a criminal case at all till the accused offers character evidence. And he offers relevant character evidence. If it's a violent offense, he can offer relevant character evidence of peacefulness. If it is honesty, he can offer dishonest offense, he can offer evidence of his own honesty. Relevant character traits, relevant to the crime charged. Habit, you prove by specific instances of routine practices. We'll talk about that on Saturday as well. Experts, we already talked about. It's beat. And you must show a scientific basis. That's 4 P's and a T.
Can you remember repeat the P's?
Principles of science, potential for error, peer review, publication, testing.
Thank you, Professor Horn.
You're welcome, Joyce. Real and demonstrative evidence. If you're doing recreations, you're going to have to show that they are, in fact, substantially similar to the actual event in order to establish a basis for the jury to be able to make that comparison. Privileges and policy reasons for other exclusions. You've got a handout on this. The marital privilege point is very easy if you look at that handout. It starts, we give the highest level of protection to confidential marital communications, but you've got to, each one of those words has to be met, must be confidential, must be during the course of a valid marriage, and it must be a communication of some sort. If it is, either side can protect the disclosure of that information forever, even post-divorce. Look at it because there's different rules regarding everything else, but please look at that because that's an area we can clean up pretty well when we look at it on Saturday. Attorney-client privilege, anyone necessary for the delivery of legal services on both sides of that equation are covered by the attorney-client privilege. Physician-patient privilege, only in those jurisdictions that have one. Mass doesn't. We have, and the federal rules have a psychotherapist-patient privilege that we protect. Fifth Amendment privilege, the right not to testify, not to be compelled to testify if you believe the answer might reasonably tend to incriminate you. If you have a grant of immunity, that answer can't reasonably tend to incriminate you, and you can now be compelled to testify. Look at what they're asking. Are they asking, is it possible to compel? Are they asking is, does the person have the right to exercise the Fifth? The Fifth Amendment can be exercised if you reasonably believe the answer might tend to incriminate you. In a civil case, that can be commented upon. Evidence of insurance is inadmissible. We're going to see some of the questions early on. so that they say, but there's, like every other rule, it's an exception. Same thing for subsequent remedial measures. We want people to make unsafe conditions safer, but if ownership or control are controverted, then the subsequent remedial measure can come in. Compromise and plea negotiations. We want people to resolve their controversies, and we're going to encourage them to do so. Look at this language here that's in pages 16, 17, and 18, because we're going to protect some of those offers of compromise and settlements, and we're not going to give the same protection to offers to pay medical expenses and the like. Best evidence rule means really the original document rule. Look at the information on that at page 18. Then we get to hearsay. You've got to get the entirety of that definition down. Did I already tell you if you give me 25 of these, you get a 5 on the quiz, right? There's no way around memorizing the entirety of what 801 now requires. Is it an out-of-court statement offered to prove the truth of the matter asserted therein? If it is, it's hearsay, unless it's a party's own statement offered against a party. Or an agent statement. That agent either has to be authorized to speak, or the statement concerns something within the scope or course of that agent's duties. Or it's a co-conspirator statement made in the course of or in furtherance of the conspiracy. And those are all easy. Party, agent, co-conspirator. That's all sort of an agency relationship if you think about it there. But then the next one is a bigger leap. Or it's a prior statement of a witness who testifies at trial. And it's one of identification made after perceiving someone. Or it's inconsistent and under oath, substantive in impeachment, or inconsistent only for impeachment. Or it's a consistent statement offered to rebut the express or implied charge of recent fabrication, contrivance, improper influence, or motive. You have a minute and 48 seconds to read the entirety of the question, to draw on and apply the applicable law and figure out the answer. There is no time to be thinking about what the law should be. You got to know it cold. And if you do, and then you apply it mechanically, this is an area that becomes pretty easy. We don't look for an exception to the hearsay rule if the rule doesn't apply. So if it's not offered for the truth, non-hearsay. If it's not an out-of-court statement because it's saying it right here, non-hearsay, we're done. But if it is a hearsay exception, if it is hearsay, then we've got to look at a whole bunch of exceptions, right? I always like to start with the unavailability ones because they're pretty easy to memorize. What renders a declarant unavailable so that that door is open? Debbie. The declarant must be dead, exercising a privilege, beyond the subpoena power, or incompetent. If they are, then I've got 2 Ds and 3 Fs to use. How do I remember that there are 2 Ds and 3 Fs? If you got 2 Ds and 3 Fs in law school, you'd be unavailable for the purposes of taking the bar exam. Dying declaration. Homicide or civil case. Can't have it with an A and B with a deadly weapon. Homicide or civil case. That's what the rule says. The client doesn't actually need to be dead to put it in a civil case, but they have to be unavailable. Declaration against penal or pecuniary interest at the time the statement is made. Not when it's offered. Whoever's offering it, it's always in their interest to offer it. That's why they're offering it. At the time the declarant made it. Former testimony had to be subject to cross at the time it was given. Why? Because it'll never be crossed here because the witness is unavailable. Family history, records of dates of birth and death and the like. Lastly, forfeiture by flight of a witness. You have done something improper to procure the loss of that witness's statements. Since you have, you've now forfeited your right to complain about the lack of cross-examination. Through your wrongdoing, you will be penalized, and that witness's prior statements may be received as such. If it's not one of the 2 Ds and 3 Fs, we can go over to the other side, 803, which says availability immaterial. Doesn't make a difference whether the declarant's unavailable, except for the one you now know, past recollection recorded, because of the foundation that's needed in order to put that into evidence. The only hearsay exception which requires the declarant to be available. The only one. Present sense impression and excited utterance, we talked about that. The distinction is minimal, right? Look at the statement of mental, physical, or emotional well-being, the Hillman doctrine as well. Business records, look at the information here as to under what circumstances you can put a business record. A lot of the records exceptions, and there's about a half a dozen of them, say that because we use this information, these documents, to run our municipal offices, our private businesses and the like, and we rely on them as a regular matter, that we consider them sufficiently trustworthy that they should be admitted. Learned treatises, just like past recollection recorded. If it's coming in, the information, it has to be read into evidence by the proponent. Read into evidence. The physical thing doesn't come in, it has to be read. And then lastly, the right to confront witnesses. In a criminal case, when we're done our analysis on hearsay, and we say, okay, I found a hearsay exception, it comes in. Because of the Sixth Amendment, Crawford and Melendez-Diaz, your analysis is not done yet in a criminal case. If it's what the Supreme Court refers to as testimonial hearsay, what I define as an accusatory statement to or from a law enforcement official. Accusatory statement to or from a law enforcement official. I tend to visualize that as the witness sort of pointing their finger and saying, Jim did this to me. So think of it as an accusatory statement to or from a law enforcement official. If it is, and an excited utterance is not considered one as a general matter, if it is an accusatory statement to or from a law enforcement official, the declarant has to be available for cross-examination. Has to be. You might be able to get the information in without, but it won't stay in. The witness has to be available for cross because of the Sixth Amendment, Crawford and Melendez-Diaz. And if that witness is not, and it's testimonial hearsay, it's an accusatory statement to or from a law enforcement official, that information is inadmissible. The more recent cases have really started to draw a distinction on 911 calls and the like. The more recent cases have said that a 911 call when you're asking for an ambulance and the like, that's more a cry for help than an accusatory statement to 911 police saying, my wife just shot me. So you may have to draw that distinction. But what you need to look at it is it an accusatory statement to or from a law enforcement official, or is it this other part, this request for emergency medical assistance or things like that, or not even involving law enforcement at all, and then you're probably better off because you're less able to prove the accusatory statement to or from a law enforcement official. You've got your schedule. If, by the way, if you miss a quiz, you must make it up prior to the start of the next class or you cannot make it up. We have 1, 2, 3 classes left. This goes fast. Try and ramp up, get your body of law down, come in with what questions we have, and we'll try and plow through them to get a better understanding. Yep?
We get our test results on Saturday?
Yes, you should. I had hoped to have them for you today, but the 10 short answers haven't been finished yet. Everything else is done. As soon as he finishes, they'll put them in the computer. I'm sure we will have them for you. We'll have them for you Saturday. Okay? Anything else? Put your stuff away, take out a piece of paper, and put your name on it.